return the verdict.
Thank you. All right, at this time, ladies and gentlemen of the jury, my bill is going to go ahead and pass out the jury instructions that I'm going to read to you. And if there's anyone in the courtroom who does not wish to stay through the jury instructions, you can go now, because we're going to lock the courtroom while the instructions are being read. Ladies and gentlemen, these are your copies. You get to take them back with you in the jury room. So if there's any part of it while I'm reading it to you that you want to highlight, underline, circle, feel free. They're each of your individual copies so that you can have those back in the jury room to review as you make your decision. Now, I completely understand that you're smart people and you could read this to yourself, but the law requires that I read it to you out loud. So I just ask if you read along as I read that to you. And I'm just going to give my deputy a second to lock the courtroom so that we're not interrupted in any way. Thank you. Members of the jury, I want to thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Qiu Feng, the defendant in this case, has been accused of the crime of murder in the first degree. In this case, Qiu Feng is accused of murder in the first degree. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Edward Lee Tudor was killed by Qiu Feng, and you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the first degree, or was murder in the second degree, or was manslaughter, or whether the killing was excusable or the result from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Number one, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Qiu Feng may be found guilty of murder in the first degree or any lesser included crime. Murder in the first degree. To prove the crime of first degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Edward Lee Tudor is dead. Number two, the death was caused by the criminal act of Qiu Feng. And number three, there was a premeditated killing of Edward Lee Tudor. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must be passed between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convinces you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Qiu did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because the act in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasonable fury. And C, there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused the death. And E, Qiu was, in fact, so provoked and did not cool off before he committed the act that caused the death of Edward Lee Tudor. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on an adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Qiu committed murder in the first degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused the death of Edward Lee Tudor, you should find the defendant guilty of murder in the first degree with discharge of a firearm causing death. A firearm is legally defined as a weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the actions of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are murder in the second degree and manslaughter. Murder in the second degree. To prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt. Edward Lee Tudor is dead. Number two, the death was caused by the criminal act of Qiu. Number three, there was an unlawful killing of Edward Lee Tudor by an act imminently dangerous to another and demonstrating a deprived mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a deprived mind if it is an act or series of acts that one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Qiu did not have a deprived mind without regard for human life because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a deprived mind without regard for human life because he acted in the heat of passion based on an adequate provocation, again, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasonable fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused the death, and Qiu was in fact so provoked and did not cool off before he committed the act that caused the death of Edward Lee Tudor. If you have a reasonable doubt as whether the defendant had a deprived mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find the defendant guilty of second-degree murder. If you find that Qiu committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused the death of Edward Lee Tudor, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing death. A firearm, again, is illegally defined as a weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the actions of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Manslaughter. To prove the crime of manslaughter as a lesser, the state must prove the following two elements beyond a reasonable doubt. Number one, Edward Lee Tudor is dead. Number two, Qiu intentionally committed an act or acts that caused the death of Edward Lee Tudor. Every person has a duty to act reasonable towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I had previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justifiable, or excusable, and which caused the death. If you find that Qiu committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. Again, a firearm is the same definition as before. I won't read it to you again, it's right there. If you find that Qiu committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. The defendant had entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which his witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefits in order to get the witness to testify? Had any pressure or threats been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to the consideration of his testimony that you apply to the testimony of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the forms of exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Please remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is my job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it is as follows. This is the verdict form. It'll go back with you with all the evidence. It is 2 pages. I'm going to staple it together. It reads the defendant's name at the top, our case number, verdict. Very easy. It says, we the jury find, check one and only one on this form by inserting a single check mark on the line next to the description of the verdict which you have found. Number 1, the defendant is guilty of murder in the first degree as charged in the indictment. Number 2, the defendant is guilty of murder in the second degree as a lesser. Number 3, the defendant is guilty of manslaughter as a lesser. Number 4, the defendant is not guilty. Now, as I read to you, there are some special instructions as to each line. So if you find the defendant guilty of murder in the first degree, you must further find if the defendant did discharge a firearm causing the death of Edward Lee Tudor. There's an easy yes or a no. Same thing with second degree murder. If you find second degree murder, again, same question, yes, no. Manslaughter is a little different. If you find him guilty of manslaughter, you must find if the defendant did carry, display, use, threaten to use, or attempt to use a firearm. Again, yes, no. Of course, if it's not guilty, there's no special instructions. There's one form, it's a verdict form on the bottom. The foreperson will sign and date the verdict form. Now, I haven't gone over this, but I also have you put your seat number, because when we read the verdict form, we will only read it by seat number. I haven't really told you what your seat number is, because we haven't come to that, but the first row starts out seats 1, going all the way across, then to the top, to the bottom. So we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, okay? So if you put your name, sign and date the verdict form, and your seat number. When we read the verdict form, we will not read your name into the record. We will only read your seat number, all right? The next section says, in addition to the verdict form, there is a special finding form. That's that second line underneath that I just went over on the verdict form. The charge of murder in the first degree and the special finding associated with that charge are interrelated because a special finding that the defendant discharged a firearm causing the death is an essential element of murder in the first degree. In this particular case, because a firearm is alleged. Accordingly, you should not return a verdict finding the defendant guilty of murder in the first degree unless you also find in the special findings that the state proved the allegation that the defendant discharged a firearm causing death. On the other hand, if you decide that the allegation that the defendant discharged a firearm causing death in the special finding has not been proved beyond a reasonable doubt, then you should not return a verdict finding the defendant guilty of murder in the first degree. This is also correct on murder in the second degree, all right? In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violations of these instructions or any other instructions I have given you in this case, you must tell me by giving a note to my bailiff. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote on the note. If you have a question, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any question, if I can, in writing or orally here in open court. I will tell you, unless it's about food or a smoke break, I'll have you come back in. So food and smoke break, I'll do it in writing. Other than that, we'll do everything here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room when you begin to deliberate. And again, as I indicated, I believe yesterday, gun and bullets not at the same time. We're going to put the guns in first, and bullets out. If for any reason you need the bullets, not, and my bailiffs will exchange them, okay? There's actually two firearms, they'll both go back, but all the bullets will stay out here, all right? But if you need them knocked, they'll exchange them for you, no problem. And please don't mess with the locks that we have on our guns, okay? Don't try to take the locks off, just leave them the way they are. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Can I have the lawyers at the bench briefly? Juror number 13, you are my alternate juror. And it's funny that you asked me about the alternate juror. So I am going to excuse you at this time. We only can have 12 make a decision. So at this time, we have your electronic device here. I have a certificate of appreciation. I'm going to take your juror badge and your excuse. If you would like to remain to see what the jury does for their deliberations, you're more than welcome to stay. If you want to go, I can just give you a number where you can call to let you know what happens. I can do that too. So at this time, you're excused. But I appreciate your hard work and dedication to this case.
I appreciate it too.
All right.
I enjoy it.
For the rest of you, grab your notes, grab your instructions, grab your jackets. You get to take everything but your electronic devices. We just put them there for, we didn't know who's who. So don't take those. If you all go on back, and my bailiff will be in a few moments with the evidence and the jury verdict form.